With this lecture, we make a transition. Up till now, we've been talking about the subject matter of trademark law, the things that can function as marks, talking about word marks, talking about non-word marks, eligibility questions of trade dress, product design, product packaging, and the challenges posed by the functionality doctrine and the possible forces exerted on trademark law to exclude subject matter because it's the primary subject matter of patent or copyright law, and that's the traffics, the functionality doctrine, and the Daystar decision, respectively. We now close the book on that chapter and move into the next one, and that's the one that considers, once we know we want a trademark, how does one go about securing trademark rights? And this lecture is going to focus on the kind of use that is necessary to perfect trademark rights to gain priority in a mark. And so traditionally, the United States has a use-based system. And that basically means that what you need in order to get a registration for your mark is a use in commerce, put that in quotes, and priority was traditionally based on who is the first to use a mark, not who is the first to register a mark. And there's been a change to that worked by the introduction of intent to use applications. This is a registration method, not as a state of mind. So the traditional first to use orientation of the United States was somewhat unusual compared to our trading partners, and reciprocity agreements with systems with nations that use first to register approaches gave foreign applicants a kind of a leg up in the United States in certain cases. And there were also frustrations that accompanied the first to use system, insofar as sometimes a company would make substantial investments in a mark. They'd be gearing up, ready to go, but for strategic reasons weren't actually in the market yet. And that always offered the possibility of surprise if someone jumps in the market first, using the mark that the company was planning to use and had already made investments in. One way companies dealt with this was to engage in so-called token uses, almost sham-like uses designed not really to engage in serious commerce, but to make a sale or some kind of transaction that would give a company trademark priority, and then they don't necessarily follow through with the uses that would have been necessary or that we would want someone to do if we really want them to perfect rights to a trademark. And even for those cases where we think token use may have been acceptable as a way to kind of, get in line, that wasn't always available to every kind of business. And so enter the intent to use application. This allows the filing of an application by one who has a bona fide intent to use, and that will give that entity priority to the mark in question once the use is perfected. And so if you file an ITU, you have to later submit a statement that the mark is in fact being used within 6 months of your notice of allowance, and that can be extended for 6 months, extensions for good cause up to 24 months. And Section 7C of the Lanham Act provides that filing an ultimately successful registration application, whether it's based on use or intent to use, is constructive use of a mark, giving priority to you against everyone except a prior user of the mark, a prior filer of an application to register the mark, or a prior filer of a foreign application to register the mark under certain circumstances. And so the priority you get out of an intent to use application is both offensive and defensive, or it has both offensive and defensive uses. So imagine a hypothetical. A files an ITU application. B makes the first actual use in commerce. A's application is published. B files an opposition saying, I had a prior use. This is a 2D bar, a statutory ground for refusing registration because it's likely to cause confusion with another mark. The ITU applicant can rely on their 7C priority, assuming they perfect their application and the mark then is later registered. Likewise, A files an ITU application, B makes an actual use and files a use-based application, B's application gets published, A can oppose asserting a constructive use date for the Section 2D bar, again, assuming that A later perfects its use and has a granted application. And of course, if there's a use prior to the filing of an ITU application, that use will give priority that would defeat the ITU application. And the kinds of uses that can give priority is the subject of the next lecture. Thanks for watching.